Mr. Clement, can I ask you about the facial nature of this? Because my understanding is that to strike down this statute is facially unconstitutional. We would have to conclude that there's no possible way for this law to govern these entities and their conduct. So first, do I have the standard right?
With all due respect, I don't think so. In the First Amendment context, as my friend was indicating, the question is whether or not the statute has a plainly legitimate sweep. So it's not the Salerno, if there's one little application somewhere, that's enough to save the statute.
But I mean, whose burden is that? I thought it was your burden to say that this statute, in almost all of its applications, or in most or a substantial number or something, would be unconstitutional in order to get it facially stricken.
So two things, Your Honor. I think our burden would be our burden to say that this statute doesn't have a plainly legitimate sweep. In fact, it is our position, and we did make this argument below and succeeded, that this statute actually has no constitutional application. And part of that is because none of this statute, at least none of the part that's in front of you today, applies unless you are a covered website. And the website...
But wait, I don't understand. I'm sorry. So no application, but we have so many different applications of the law in this situation precisely because it is so broad. So how can you say that?
Because the statute only applies to websites that are a handful of websites that meet the viewership threshold or the total sales threshold. And it's not our only argument, obviously, but one of our arguments is you can't regulate expressive activity in that kind of
and those websites
does the Florida law cover Gmail?
The Florida law, I think by its terms, could cover Gmail.
All right. So does Gmail have a First Amendment right to delete, let's say, Tucker Carlson's or Rachel Maddow's Gmail accounts if they don't agree with her or his or her viewpoints?
They might be able to do that, Your Honor. I mean, that's obviously not something that has been the square focus of this litigation, but lower courts...
Well, if they don't, then how are we going to judge whether this law satisfies the requirements of either Salerno or overbreadth?
So it's, again, I think it's the plainly legitimate sweep test, which is not synonymous with overbreadth, but in all events, since this statute applies to Gmail, if it applies at all, because it's part of Google, which qualifies over the threshold, and it doesn't apply to competing email services that provide identical services, that alone is enough to make every application of this statute unconstitutional.
Doesn't apply to... go ahead.